Welcome, everyone. Welcome all Eli's, colleagues, and friends to this conversation about the Equal Rights Amendment, Equal Means Equal, and our new campaign, Final Impact for the ERA. I want to start by giving you a little personal history on how I stumbled onto this fight, because I think, like many of you, I grew up as an overachiever, and I had absolutely no sense that I was unequal or inferior in any way. But in 2008, when I was showing my first feature film, A Single Woman, about the life of Jeanette Rankin, our first Congresswoman, at the Smithsonian Institute in Washington, D.C., I was approached by a reenactress who was dressed up as Alice Paul. And she came up to me and she said, "I'm Alice Paul, and I'm back to haunt you because you've done nothing to ratify the Equal Rights Amendment, and women in this country still don't have equal rights." And I honestly was completely stunned and shocked. I had no idea at all that I wasn't equal legally in our Constitution. And it made me very, very upset. I felt betrayed, I felt tricked, and I felt like something had to be done about it. Partially because a lot of times women, when they aren't succeeding, they blame themselves. And that blame does not belong to them. That blame belongs to an uneven, unequal system in our Constitution, because our Constitution is our foundational document, and our whole society and our laws and rules and the culture that we live and breathe comes from that foundation. So as soon as I started researching the Equal Rights Amendment in 2008, I realized that this was a mission that I really couldn't shy away from. And since that time, I have been single-mindedly focused on achieving the ratification of the ERA. To give you a little history about the Equal Rights Amendment, first I'll tell you what it is. It's a very, very simple statement which says, "Equality of rights under the law shall not be denied or abridged by the United States or by any state on account of sex." It seems very basic, especially today, and yet we haven't managed to achieve it. And that was shocking to me. And I thought, well, it can't be that hard. First of all, 96% of Americans believe that men and women are equal. The problem is that over 85% of them believe that that equality is already provided for in our Constitution. And then there's a whole wide swath of people who believe that the Equal Rights Amendment was completed in the 70s, and they correlate the massive second wave feminist movement and their perception of bra burning and women's liberation with the completion of the Equal Rights Amendment. But what it actually correlates to is when Congress, our United States Congress, the House and the Senate, passed the Equal Rights Amendment, and then President Nixon signed it. The part that is missing in most people's understanding of the amendatory process is that after that occurs, the amendment must go out to all 50 states, and it needs to be ratified by their Congress, their House, and their Senate. And that can take a very, very long time. In fact, it took so long, frankly, that most people forgot that it hadn't happened. And so when I stepped into this fight in 2008, I was dealing with a great deal of educational, I guess there was an educational deficit. And so not only did I have to convince people that this had not happened, but I had to convince them that it still had to happen. Because most people believe that with all the various acts, the Equal Pay Act, the Pregnancy Discrimination Act, the Violence Against Women Act, that all of these acts and statutes took the place of the ERA. And so the ERA was no longer necessary. That couldn't be farther from the truth. Acts and statutes can be changed at the whim of whatever political party is in power. It can go back and forth. It can constantly be shifting. But a constitutional amendment is bedrock. Once it's in there, once 3/4 of the states have spoken and they've put it into the Constitution, it is extremely difficult to remove. That's why our campaign right now is of so much importance, and I'll get to that momentarily. So from 2008 to 2015, I focused on educating and reactivating the American public by explaining to them, no, women still did not have equal rights, and we needed to complete the ratification of the ERA. So after speaking in schools and traveling around and doing PSAs and websites and so forth, I decided to make a documentary film. And I'm very grateful that I had the participation of thousands of wonderful women, including Yale classmate Martha Dempson, including Gloria Steinem, including my executive producer Patricia Arquette, and my dear mother, Liz Lopez, who was my initial funder, to all my Kickstarter people, and my husband, who stood beside me through this entire extremely long and arduous process that led to the release of the film Equal Means Equal in 2015, which went on to win Best U.S. Documentary at Michael Moore's Festival and was a New York Times Critics' Pick. And what we did was we took that film to the 15 unratified states and the ratified states, but with a focus on the unratified states, and we started to do screenings and house parties where we could re-educate, organize, and mobilize women in local communities to once again pick up the mantle, pick up the torch, and fight for the ERA. As a sidebar, and we can discuss this later, there was an artificial deadline that was placed on the Equal Rights Amendment in the preamble of the Equal Rights Amendment, which was never voted on by the states and which all constitutional scholars have agreed is not valid because it imbalances the balance of power between the federal government and the states if the federal government can suddenly decide that one amendment gets 2 years to be ratified and another gets 200 years, which is the case with the 27th Amendment, which took 203 years to ratify. In the case of the Equal Rights Amendment, as I mentioned, there was this illegal deadline placed in the preamble that gave ERA only 7 years to achieve the 38 states needed. And when that deadline ran out, even though then President Jimmy Carter, who is a wonderful man and a wonderful supporter of the ERA, extended the deadline by 3 years, by that point, the forces, and we can discuss what those forces were, but at the time, it was a combination of cultural forces under the rubric of Phyllis Schlafly, the original AstroTurf, who was bought and paid for by multiple interested parties that did not want to pay equally, the insurance companies, on and on. By that point, there was a strong misinformation campaign and anti-ERA campaign that stepped in so that between the 7 years and the 10 years, no other states were achieved. But in the first few years, 35 states were achieved. So when I walked into this fight, completely ignorant, there were only 3 more states that we needed to get to complete the ratification of the ERA. And what we did is we used the film to organize these women to go back to their state governments and petition votes on the ERA. And in a very short order, we achieved ratification of the final 3 states. Nevada in 2017, thanks in great part to a fantastic state senator by the name of Patricia Spearman. Illinois in 2018, which was incredible. It was I can tell you more about what it took to do Illinois, but again, the new fight for ERA has been extremely inclusive and intersectional, which was the complaint of many feminists that the ERA was a bourgeois white women's issue. It couldn't be farther from the truth, but that was the perception. And this iteration, it has been an extremely inclusive and diverse group of women and our allies that have pushed this over. Then what occurred is a case called Bostock happened. Bostock was a case where the federal government, the Supreme Court was trying to decide whether gender was covered by the term sex. And this is very important for the ERA because if sex covers gender, that means that the ERA covers all genders. It means it covers the LGBTQ community, which is incredibly important. And it does. The Supreme Court ruled that yes, the term sex covers all genders. So now we know that the ERA not only provides equal rights for women and girls, but for all people, no matter how they present, no matter where on the spectrum they lie in terms of a gender identity. So Illinois, we ratified in 2018, and then our longest and hardest fight occurred in Virginia, the seat of the Confederacy. It was an extremely brutal, grueling 4-year knockdown, drag out, where we had to actually end up moving to Virginia and flipping that house and getting rid of some very, very unpleasant men in charge who wouldn't even let the ERA onto the floor for a vote. And we got rid of them. We got the first female ever Speaker of the House in Virginia in the district that myself and my Vice President, Natalie White, moved to. We got the first Black man ever elected, and we got rid of a 29-year incumbent who was truly an unpleasant person in many ways, and thank God he's gone. But we achieved the ratification of the 38th state on January 27th of 2020. And we were elated. We were over the moon. We just couldn't believe that after almost 100 years, we had finally gotten all Americans equal rights regardless of sex. And it couldn't have been hours before Donald Trump directed then Attorney General William Barr to send an illegal letter to the U.S. archivist ordering them not to publish the ERA. Now understand, the ERA is law. There's no ifs, ands, or buts about it. But the publication of the ERA is crucial because what it does is it signals to the courts and to the country that this is the law and you must follow it. So it was kind of a sneaking around the back door and saying, yeah, this is law, but by the way, don't publish it so that no one can use it. No one can adopt it. No one can enforce it. And so we immediately filed suit to compel the archivist. His name was David Ferriero, to compel him to do his mandatory non-discretionary duty and publish the ERA. And I'm so proud and so grateful to have one of the most brilliant legal minds in the country on the Equal Means Equal team, Attorney Wendy Murphy, who, if you look her up, you'll see all the things she's been involved with, but she really has taken this on as a mission alongside me to make sure that this government does not get away with withholding these rights that are due to us from over a century of struggle. And she immediately was prepared to file, and we filed against the archivist, and we started fighting back. Soon thereafter, the states of Illinois, Nevada, and Virginia also filed in a basically an identical suit saying, hey, we're the states that just ratified this. You need to publish this. And so that began a 3 to 4 year legal battle that we thought would end immediately upon the election of now President Joe Biden. Because Joe Biden has been nothing if not an ERA cheerleader his entire life. He loves the ERA. To hear him speak, he would like nothing better than to see that ERA is in the Constitution. And yet, when he had the opportunity on the first day of being in power, he chose to continue to fight us in court. to continue to use the same legal arguments that Donald Trump had been using. And what's even more dispiriting is to speak publicly to say that he supports ERA and he believes it's absolutely valid, da 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 da, but in the back say something completely different through his lawyers. Now, what Biden has been saying is that he would love nothing more than to see the ERA adopted. However, Congress must act. Now, we all know that's complete nonsense. The role of Congress was completed in 1972 when it passed it out of Congress. And his lawyers said as much to us in court. So it's very disingenuous, very upsetting that he's speaking out of both sides of his mouth, and we are losing rights like crazy. In the Dobbs case that recently occurred, where we lost the right to control our own bodies, they had the opportunity. The Center for Reproductive Health, or the group that was presumably representing the women, had every opportunity to use the federal Equal Rights Amendment to say, hey, Supreme Justice Alito, you're saying there's no textual basis to protect women's bodies. That's not true. We have the textual basis in the Equal Rights Amendment, which says essentially, if you can't do it to a man, you can't do it to a woman. So unless they're willing to direct men to have vasectomies or not have vasectomies or whatever the hell they want to direct them with their bodies, they cannot do it to us. And it was very dispiriting that despite this knowledge, they chose not to use the ERA. And we're seeing this in case after case in Texas, in Nevada, where they are not using the state or the federal ERA to say, hey, we demand strict scrutiny. We demand equal protection of our laws. And why isn't this happening? So that's a whole nother disturbing question. But another one of our legal counsels, Arlene Rocky, she reached out to that team and 14 times to tell them to use ERA, and they chose not to. So here we are at a turning point, and now I want to talk to you about what we've decided to do about this. The way we see it, we have between now and November 4th to get this president to do the right thing, which is simply make a 3-minute phone call to his employee, Colleen Shogun, the Archivist of the United States, and say, hey, Colleen, disregard the illegal OLC memo from the last administration and publish the ERA. And that is what we must do. We must leverage the power that we have now as voters and women and equality activists and say, Mr. President, pick up the phone and make that call. It's the best thing he could do to save his campaign, to ensure his presidency, and to claim his place in history as the most important. It would be the most important thing he could possibly do. We just cannot let this stand. We have this moment in history. We have this opportunity. Let's make it happen.